to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'm going to begin with a reading of the procedures for the meeting tonight. Appeals will be heard first, and then other business of the board will be conducted. You may stay but are not required to remain until your appeal has been heard. And actually tonight we have a continuation of an appeal that was done in March. All who speak or testify will be sworn in as a group or individually at the discretion of the chairman. And when you address the board, you must provide your name and address for the record and speak into the microphone, as all our proceedings are recorded. If you do not, your input may not be recorded, and all who testify may be subject to cross-examination by an attorney. All documents, photographs, and other physical evidence presented will be accepted by the board unless withdrawn by the offerer or an objection is made as to the admissibility of the document, photograph, or other physical evidence. The chairman will rule as to whether those items being offered will be accepted or rejected. The zoning administrator or staff members will present a brief summary or a statement of the appeal. The appellant will then be given an opportunity to speak and present his or her evidence. Anyone else in favor of the appeal will also be given an opportunity to speak, and then anyone opposing the appeal will be given an opportunity to speak and present his or her evidence. Depending on the circumstances, the board may impose reasonable limits given on time given to each side. After presentation of both sides of each case, a public portion of the input for that case will then be closed. Any board member may then ask questions of anyone who has spoken or made comments on the appeal. After the discussion, a motion and second will be made by the board to either approve or deny the appeal. The vote tonight is referred to as a straw vote. Such a vote brings forth a resolution at our next meeting reflecting the board's decision. Adoption of the resolution next month is the final order of the board. And we acknowledge that issues before the board can be heated, sometimes emotional. No disruptive behavior will be tolerated. We will go to a roll call, and the roll call will reflect Mr. Robert Bartold is sitting in as a substitute for Mr. Roberto. Roll call, please.
Mr. Grubbs?
Here.
Mr. Martin?
Here.
Mr. Price?
Here.
Mr. Reininger?
Here.
Mr. Bartold?
Here.
Now, anyone who is going to testify this evening, I will ask to stand and raise your right hand. Do you swear or affirm that you will tell the whole truth and nothing but the truth in matters before the Board of Zoning Appeals? Say, I do. Thank you. Okay, we have a continuation of the case from last month, which is BZA 2013-001. Subject property is 12190 East Miami River Road, Cincinnati, Ohio. Applicant Terry Blozer, and the owner is Fairfield Church and Nazarene, and the application is for conditional use for religious place of worship. So, if staff presentation, proceed. Thank you.
All right. Thank you, Mr. Chairman. You'll recall the subject property is at the very northern portion of the township, right at the intersection of Colerain and that Kemper. It's up there. To remind the board of the case history here, back in 2011, the Board of Zoning Appeals granted an approval of a conditional use for a modular building, okay, to be used to house the church office while the church constructed an addition. This approval was conditioned on the removal of the modular building once the church structure was built, or after 24 months. So and then in May of 2011, the BZA granted another conditional approval for a temporary maintenance building at the Fairfield Church of the Nazarene. Mr. Blosser came into our office and said, hey, my 24 months is running out. I need to, we never ended up building the addition on our church. I need to renew the conditional use permit for this modular building. At which point, I thought about that quite a bit, and I didn't understand what a conditional use permit for a modular building was, because a modular building isn't listed in the use table. In fact, it isn't a use, it's a structure. And so as I reviewed the case history, I saw something that was done in the past that I wouldn't do again. And so I was trying to fix what had been done in the past, because I didn't understand what a conditional use permit for a modular building was, and I don't believe that you can issue those. So what I brought to the board in March of 2013 was, what Mr. Blosser brought to the board in March of 2013 was a conditional use for the use on the property. And the use on the property is religious place of worship. At that hearing, we got sort of down into some significant details about the case history here. And what happened was, several months before the effective date of our current zoning resolution, Mr. Blosser was issued a zoning certificate for religious place of worship at this location and has an approved site plan. At that time, religious place of worship was an as-of-right use in a residential district. So there were no conditions upon it that were separate or distinct from any other use that was as-of-right. Now, our current zoning ordinance places 3 conditions on religious place of worship in a residential district. So at the last hearing in March of 2013, March of this year, we had a dialogue about what to do about this situation. There are many churches in Colerain Township that were approved in residential districts before 2006 that don't meet the criteria of our current zoning ordinance, and as such are non-conforming uses in those districts, right? A non-conforming use has some pretty significant limitations as to how they can expand in the future, and they don't enjoy the same privileges with respect to signage, for example. So since March of this year, and since that our last hearing, I spoke with Mr. Blosser and I said, hey, I believe that I can issue you a non-conforming use certificate that will basically take care of or nullify those, in my opinion, erroneously issued conditional use approvals. So you would be good when it comes to the modular building and the maintenance building. But Mr. Blosser said, yes, but in the future, if we want to expand or if we want to put up a certain type of sign, wouldn't we need to get this conditional approval? And I said yes. So that's why we're here this evening, is to continue the conversation that we had in March, and to come to some resolution about what to do, about Mr. Blosser's situation, but also in the back of our heads, we need to think about what to do about non-conforming churches in residential districts and how we're going to handle those, because I know for a fact that we're going to see more of these. So that's why the issue is timely. That's why Mr. Blosser's appeal is timely, and that's why I think that tonight's discussion is going to have implications moving forward. So just to remind you again of the site, this is Kemper Road. This is 27 near the border. The river is right here, and this is a driveway that comes up to the site, and here's the church. This is the modular building. This is another modular building. The issue that we had in March was that, hey, this parking was well, we'll see here in a minute. I'll hold that thought. Hold on. This is a zoning map. It's in the R2 zoning district. This is the border, so there is, this is the border. This is not Colerain here. So in our ordinance, in order for the Board of Zoning Appeals to issue a conditional use, it has to meet 3 criteria. Okay, the use, in order for you guys to approve it, the use has to be a conditional use permitted with the approval of Board of Zoning Appeals in the district where the subject lot is located. That is the case in this situation. Number 2, the use is in accordance with the objectives of the Colerain Township Comprehensive Plan and Zoning Resolution. So it isn't at odds with the objectives of these documents. Number 3, the conditional use will not substantially or permanently injure the appropriate use of neighboring properties and will serve the public, pardon that typo, convenience and welfare. The use will, and 4, the use will not create excessive requirements at public cost for public facilities and services and will not be detrimental to the economic welfare of the community. So these are the criteria that our zoning ordinance requires you to use in order to make your decision this evening. The 3 conditions that are in our ordinance related to religious places of worship in residential districts are, number 1, all buildings and activity areas and parking areas shall be located a minimum of 50 feet from all lot lines when located within or adjacent to the residential zoning district. This is a problem because the site plan that was approved allowed for a parking lot within 50 feet of a lot line. Number 2, the religious place of worship shall meet the buffer requirements and uses within the B2 zoning district. So that means that in this case, where the B2 zoning district abuts a R6 or R2 zoning district, a 40-foot landscape buffer has to be used. And then 3, no part of the parking area shall be closer than 5 feet to the side or rear yard lot lines unless it's adjacent to a residential district, in which it shall be set back 50 feet from the property line. So these are the sticking points, I think. One other item to think about here is a law. It's a federal law called RLUIPA. It stands for the Federal Religious Land Use and Institutionalized Persons Act of 2000. This law prohibits us, federal, state, and local governments, from imposing any land use regulations that impose a substantial burden, that's the key word here, on religious activities. And there was this case, and it wasn't in our circuit, but it was in the Ninth Circuit Court of Appeals, that found that the denial of a conditional use permit may impose a substantial burden. There's a lot, this is there's a lot of case law related to RLUIPA, but I just wanted to introduce you to this law because it exists and it may have implications in our deliberations here tonight. In order for us, if a RLUIPA claim, which has not been mentioned by any church in Colerain Township yet, but if we were to have to defend a RLUIPA claim, we would have to show that that the imposition of this burden is, number 1, in furtherance of a compelling government interest, and 2, is the least restrictive means for furthering that interest. And another important thing here is that if we have to defend a RLUIPA lawsuit and we lose, they can recover attorney's fees and damages. So it's kind of a big deal. So religious, and all this is to say is that religious uses in America enjoy more protection than other types of uses. So that's something else to consider here. Just to let you know of other situations in Colerain Township, this is, I'd say Kemper and Pippin. Okay, this is the Lutheran church that we talked about this, I don't know, November of last year. And it was the exact same situation where the church wanted a sign that was only permitted in residential districts to be had by approved conditional uses. Okay, so they were not an approved conditional use; they were a non-conforming use at the time. But the board granted a conditional use approval, despite the fact that there is parking within 50 feet of the side yard here or lot line here. So while every set of facts, I believe, creates a distinct case, and I don't lean heavily on precedent at all, ever, because I think that in these cases, facts are divergent in a lot of cases. Just wanted to point out that this is another example of this problem popping up in the township. Here's an example of another church that we may or may not be seeing in the future. This is at Livingston and Blue Rock, and this is a non-conforming church in a residential district with parking close to the lot lines. If they were to ever want to expand, likely they would need to become a conditional use. And I think that ultimately, as I read the comprehensive plan and the zoning resolution, I think that the purpose of these conditions is to prevent or mitigate any negative impacts that the increased traffic or maybe dust or noise would cause to a residential neighborhood. In the case of the Fairfield Church of the Nazarene, it is set back quite a ways from any existing residences, and the parking in question is actually adjacent to 27. So very little negative impact to residential, land uses, I believe, would occur as a result of, this parking lot. So in all, I've discussed the matter with our law director. He agrees that this is the best way forward. My suggestion, my interpretation of the zoning rules and our comprehensive plan leads me to believe that the Board of Zoning Appeals can, in this instance, where we have a non-conforming use, it's a church, it meets the 4 criteria that are in section 4.3, I think it is. I believe that you can grant a conditional use approval despite the fact that it doesn't meet those 2 conditions related to the setbacks of parking. So with that, I'll end my presentation.
Thank you. The applicant is here, and if you would like to address the board.
I think it's been explained pretty thoroughly, and I'll be happy to answer any questions and be a part of this dialogue as we go along, but I really don't think I have anything additional to add at this point.
Okay. Thank you. Just in terms of protocol, I'm going to close the public portion of this, and then we're going to go to the board and applicant dialogue. So I'll ask for a motion to close the public input.
Motion to close the input?
Second. All in favor?
Aye. Aye.
Okay, now, the board questions. Let's just start with Mr. Martin.
Well, I guess I'm not persuaded, to be quite honest about it. With all due respect, I don't think RLUIPA probably should not, I don't think it should have been mentioned this evening, because I do not think it's appropriate that we plant that seed in anyone's mind that that's even appropriate here. In the one case that you cited, there was a denial of a conditional use. We're not talking about denying a conditional use. I think there's a very simple explanation here, or simple resolution. I think we can grant a conditional use, but there has to be a variance. The ordinance is very clear about the setback requirement, and I don't see anything new that you've said this evening that justifies granting a conditional use where the ordinance itself says that there has to be a 50-foot setback. I do see a very easy solution, and that is to grant them the conditional use with a variance. And that's why I don't know why we're jumping through all these hoops. Why not just grant them a variance? All the reasons that you outlined, in my mind, justify the variance. The parking is abutting 27, therefore it's not abutting directly, most of it anyway, is not abutting a residential area. I think in terms of the site plan, the fact that the site plan was approved in 2006 really is not relevant anymore, because the site plan, first of all, they didn't act on the site plan. It shows existing buildings. None of that was done within the 2 years under the non-conforming use. So pretty much whatever they want to do here is going to be an expansion of a non-conforming use, and therefore even 11.8.1 and then 11.8.3, even there says you have to comply with the setback requirements. So it seems to me we're right back at the setback requirements. So it seems to me the way to do this is a conditional use with a variance on the setback requirements. But I do think that we have to then look at the terms of the variance. And the terms of the variance, in my opinion, should be that they should cut back the parking as much as possible. Since they're not building the new building, do they really need all the parking they have here? Number one. And number two, there should be some landscaping of that parking area, again, in conformance with the zoning plan and in the zoning ordinance. If RLUIPA and all these other churches are really a concern, then the bigger issue is the ordinance needs to be amended to take the 50-foot requirement out of the ordinance for religious organizations, because it's very specific. I mean, it's not a 50-foot setback in general, they say it's 50 foot for religious places of worship. And, I mean, that's pretty much what I think.
No, I think that there's a lot of good in what you just said. I think that the variance is something that was implied and I wasn't explicit about it. That if you were to grant a conditional use, you would have to vary. That's what you'd be doing. You'd be varying that condition. I think that to go back and require them to take out parking, I'm not sure that I'm comfortable with that. I don't agree with you there. I don't think that we should go back and tell them to change something that we've already approved. But what I do believe though is that this is how I would like to deal with these issues moving forward, is that any future development has to be in accordance with those three conditions. So you can't build any new parking within that 50-foot setback. Whatever's there is there. They've got a non-conforming use certificate. It's there, and it's legal. But going forward, I wouldn't allow any parking to be within that buffer area. I think we're kind of treading on dangerous ground when we start requiring modifications to a previously approved plan. Do you know what I mean?
Well, I do, except for the fact that, again, the ordinance says if it's not acted upon within 2 years, the non-conforming use disappears.
If it's, say it again.
Well, what is it, term 11.9, when any non-conforming use is discontinued or abandoned for more than 2 years. And clearly, the site plan, most of it's been abandoned.
No, the parking, which is the thing which is our subject, is built.
But then you're bifurcating the plan, so you're kind of separating the parking from, I'm not saying eliminate all the parking, but it was my understanding that you don't even use all that parking, do you? Some of it's just gravel, grass, right?
Well, let me address a few issues with you. It's not quite as simple as saying, well, let's just reduce the parking. All of the storm sewers are in the ground.
Right.
Based on the plan, based on the master site plan that was approved. So just reducing the parking doesn't help us. The additional sanctuary and education area that is there, the amount of parking was all put in that was to meet the need. So we can't reduce the parking for future use.
Well, if you build this, let me ask this, if you build this new building, this future
Yes.
building here, I know you've backed off of that now, but.
For right now, that's
Right.
correct.
And I'll ask Jeff too, if they build this additional building, are they gonna have the required number of parking spaces, or are they gonna need more?
No, that is the required,
If
per
it-
the architect.
If it was built according to that plan that was approved, then it was built according to that plan that was approved. I mean, they have a,
But wouldn't they have to they'd have to conform with the ordinance in effect at the time that they build, wouldn't they?
let me think.
There is parking spots for, I think, attendance of 500, which is what the building was designed for.
The new building.
The new building, yes,
And it's one per three seats or something?
yes. So it does meet. That's why they, in that situation, they had to squeeze all the parking they could in, and that's why it's all around there. Everything was based on the township's approval of that site plan that indicated where we put detention ponds, that indicated where we built things up. I mean, that was a farm pasture land, and it was raised about 2 or 3 feet, so it was very exactingly put in those spots.
Well, as I said at the last meeting, I mean, I'm certainly not opposed to coming up with a solution that works. I just don't want to come up with a solution that is going to keep biting us in the butt every time we deal with the church. And that's why I wish RLUIPA hadn't been mentioned, because I don't think it applies, and I don't think it applies to any of the other situations I've seen. And I don't want to plant that seed. I think we're talking about granting a conditional use, but we're also talking about granting a variance.
I think I'm all for that.
Yeah.
My concern is that an agent of the township approved this site plan at the time, and I don't think there was any understanding at the time that it was built that it was a 2-year thing. Now, that may have been reacted with some of the newer zoning laws, but I don't believe at the time that that was the case. So I understand it's a difficult situation when your past agent has approved something and then the laws are changed and then you're faced with what to do. And this site plan has actually been looked at several times since the initial one, and has always been approved by this as through the conditional use situations.
And that's unfortunate, but, you know, we're all have to
Exactly.
deal with that.
Right.
Okay, well, that's my thought.
Then we can always come back.
Sure.
For this question, Mr. Price?
Actually, just one question. I mean, how are you going to address this for future? Are we going to bring it back to, you know,
This
yeah,
this
I mean,
particular.
this particular issue concerning churches that are already non-conforming in an R2 district? I mean, is the code going to be changed, or?
My thought is that the intention of the zoning resolution is to prevent negative things from spillover effects from spilling over into the residential community from a religious place of worship use. Okay, so that's a higher intensity use than most of us are used to seeing in our neighborhoods. More cars, more whatever. In the future, when a new church comes in, I would apply these conditions to them, no problem. And that would be from the beginning. Now, the sticky wicket here is these non-conforming churches, right? And so my intention is to apply the conditions to any future plans that they have to expand, any expansions that happen. So if they would like to expand into the 50-foot setback, I would not allow that. For other churches, what I would like to be able to do is bring them in here, and as they desire to go from a non-conforming use to a conditional use, and have them ask you for a conditional use approval on a case-by-case basis. That's my intention. If you have a better idea of how to handle that, I'm all ears. Yeah.
I have a church that's the same way at the end of my street, and it's, they have parking that's literally border to border on both sides neighbors. And
Right. And that was permitted at one time, and now it's not. And so as they expand, we would like them to come into compliance with, so they wouldn't be allowed to expand into an area that.
And at the time, if this ordinance would have been in place, we've got plenty of land. Land is not the issue. We could have totally reconfigured everything and made it so it wasn't 50 feet from the border. But that wasn't the ordinance at the time.
And I'm also okay with the variance. Also.
I am okay with it,
I don't
obviously,
know
with the
another way to
variance.
approach it either at this
Yeah.
point.
Right.
Yeah, I mean, I don't see a big issue with the fact of what's currently built. I mean, it's a non-conforming use as it sits, so that's fine, it is what it is. If they want to modify something, I'm fine with it falling under the conditional use criteria, the same as if some new church wanted to go into a residential district, it would be the same criteria, correct?
Correct.
And so, I mean, that all sounds fine to me and sounds consistent with the way the code reads. What I don't understand at this particular point is what we're trying to approve here today. I mean, we're talking about, whatever is in existence now is fine. It's a non-conforming use,
Yes.
right? So is all the parking in? I'm not clear if
All parking is in, it's gravel.
500 plus spaces. is
It's
in?
all gravelled. I mean, all the everything that is future parking is gravelled with all the storm sewers in place. Obviously, you don't want to blacktop that until you build the next building because of heavy equipment and things like that. So all the base is in for all the parking lots. We actually do use those parking lots a couple of times a year when we have a large children's event. I mean, they're all used. So they are used. And I guess maybe the reason I'd like to see this resolved tonight, I'd like to not have to come back and get a conditional use or a non-conforming use again when we get ready to expand. If we could go ahead and get this conditional use, then we are already approved and this is off our table. And it's clear. There won't be an issue the next time.
Right, but to me, that's what's inconsistent with the code, because they're asking to be approved for something today via a conditional use that is not, that they don't intend to build anytime
But-
soon. I mean, that's what's different than if some other church came in that has existing, is already there.
My understanding is the conditional use is for the property, not for the building.
It's for the
Right.
use.
So the conditional use would be fine to grant tonight.
Yes.
But I don't understand why we need a variance tonight if they're not planning on doing any expansion tonight.
Mr. Martin's point is that in order to grant the conditional use, you'd have to vary the condition. Because what Mr. Martin is saying is that, I believe, and correct me if I'm wrong, is that you can't grant the conditional use because it doesn't meet the conditions. And one of the conditions, because of the existing condition is at odds with one of the conditions. And that's the disagreement that I think Mr. Martin and I are having.
And so your point, Mr. Mills, is that the standards under a non-conforming use scenario for changes are more restrictive than under
Yes.
conditional use?
Yes.
Okay, okay, so let's just assume we do that, then we grant the conditional use, we grant a variance for what exists as of today. Doesn't mean that church isn't gonna have to come back in here in the future if they wanna do something in addition to what's there today.
Well, I would say that they would move from a non-conforming use to a conditionally approved use. That's how I would look at it. And so then they wouldn't need to meet the non-conforming use requirements, the pretty strict non-conforming use requirements, because they would be now a conditionally approved, just like a new church in a residential district. You know what I mean?
Okay, so if we grant them conditional use status, and they wanna make a change in the future, they would only have to comply with whatever the requirements are for a conditional use, so they may have to come back, they may not, depending on what
That's
they're
right.
wanting to do.
They would have to comply with a new project would have to comply with the design requirements that are in the code right now, and because it's a religious place of worship in a residential district, they would also have to comply with the setback requirements that are in those conditions, those 3 conditions, for that particular use. The additional regulations. Yes.
If I may, I take exception with a little bit of that. They are here, remember, because they are expanding that non-conforming use.
No,
Yes.
they are not expanding the non-conforming use.
That's the whole reason that we're here, because they're putting the modular building.
No, the modular building's already there.
The modular building was it was not a part of the original site plan.
No, they asked for the modular building in 2011 and were erroneously told that they needed a conditional
Right.
use approval
Actually-
for the
2009.
2009, and
So
then
you've approved it twice. I mean, once and then hopefully,
Well,
now
I'm
we've got the
confused then,
non
because you're saying that leaving the modular building there is not an expansion of the non-conforming use, that they were grandfathered in from 2006?
no. What I'm
that
saying
possible?
so a mistake was made. So what that modular building is an accessory building.
Right.
Okay, so the accessory building should have been looked at as an accessory building and not as it should never have received a conditional use approval because it's not a conditional use.
Right.
It's an accessory building. So accessory buildings are permitted in residential districts, and
So he shouldn't have had to come before this board to
At all.
have that accessory structure put up, is what you're saying.
Exactly.
I understand.
I totally disagree with that. Under 11.8, that would be an expansion of a non-conforming use. They are adding, there's another structure that they're putting on that non-conforming use.
it's an accessory building.
Right.
Okay, and what I would do is I would look at the rules for an accessory use and make sure that it fits within the setbacks. You're saying that because see, here's the thing, is that this whole complex
Right.
received a non-conforming use certificate today.
Right.
So in 2009, it didn't have a non-conforming use certificate.
Right.
I wasn't here in 2009. I wasn't here in 2011. But it didn't have a non-conforming use certificate. It may have functioned. It may have been a non-conforming use, but it didn't have a non-conforming use certificate. If that makes something change. You know, one thing to keep in mind, as I have to do this a lot, is
Well, again, I just 11.8.2, I think isn't it exactly applicable? The Board of Zoning Appeals shall have the power to grant the extension of a legal, non-conforming use or building upon a lot or tract of land occupied by such use or building where such extension is necessarily incident to the existing use. Provided, however, that the floor area is not exceeding 50% of the total floor area. I mean, I think that's exactly applicable here.
And I guess, correct me if I'm wrong, but Mr. Mills' point may be that if that had been the issue brought before this board in '09, then maybe that would be the correct analysis. But since that wasn't the issue brought before the board in '09, and that the issue is now come up today, the reality is it was built 4 years ago, and it's, so, you know, it's there now under a non-conforming use certificate that was issued today. So whatever was there as of today is there as of right as a non-conforming use.
That's how I'm looking at it. And we really, one thing that I have to do a lot in my job is keep the sort of 40,000 foot perspective on all of this. What are we trying to, so look, a zoning ordinance is an imperfect tool to achieve a vision that is laid out in a comprehensive plan. Okay, so we're all trying to make Colerain a better place. That's why we're here tonight. That's why we come every month. That's why I come to work every day. What the zoning ordinance is trying to do is to prevent property values from going down, to prevent the peaceable enjoyment of private property, and so, among other things. And that's the reason I think for these rules related to churches in residential districts. So I know that it's getting down into the weeds is something that is I enjoy, but sometimes it helps me to gain a little bit of perspective to think, okay, what is the intention of this part of the ordinance, and how do we achieve that intention? And that's what I'm trying to do here tonight, is provide a way to achieve what I believe is the intention of the zoning ordinance, the intention of the comprehensive plan, which is to protect residential properties from more intense uses. And I believe that the way forward that I presented was the best way I knew how to achieve that end. So we can talk about the best way to do that, but you know, that's what we're trying to do here tonight.
Thank you. Mr. Buckle, question?
Well, number one, I agree with the existing churches probably needing, case by case scenario. Not much we can do about that. As far as the modular building, did I read somewhere that it now does have a permanent foundation? Or it should have a permanent
It needed a permanent foundation, as I understand it's a past building code.
It has, it met all the building codes of Hamilton County, yes.
So once we decide on something, there's no more issue with the modular building, per se?
Not from my perspective. It has a building permit, and once we decide on how to move forward, there will be resolution on it from a zoning perspective too.
And nothing further.
Thank you. We're at a point where we need to construct a motion to move.
Can I jump in for a minute?
Sure.
It seems to me that this is a unique issue with this particular church because of what has happened before this board over the last few years, and that any other religious institution in the township that is currently a non-conforming use, unless they've been before this board in a similar fashion, is going to be a simple, straightforward analysis when they come forward before. We won't have this issue of we approved a conditional use for a building when that's not really the proper mechanism to deal with that. So I think it's, although I appreciate what you said about, this is an issue that may come up in the future, I don't think it's as significant of an issue in the future because of these other churches won't have been before this board and have had, a mistake made potentially, years ago that we're trying to somehow fix at this point. So anyway, with that said, I'll refer back to you, Mr. Chairman.
Thank you. Any other comments from the board?
I would only say maybe Mr. Grubb to add to that, and I certainly don't know the ins and outs of these ordinances as well as you all do, but some of the things he presented tonight, if a church wants to expand and they're already at 50 feet, there's going to be an issue. Okay. So hopefully this can be a part of transitioning the past into the future. And that's, I would be happy to see that happen for all the churches in Colerain Township.
Thank you. Does anyone care to craft a motion forward?
I would craft a motion to approve the conditional use and a motion to approve a variance as, for any violations of the existing, of a conditional use as it currently sits today.
I second that motion.
Point of order, I don't think we can approve a variance that doesn't have to be noticed in that. We can't approve the variance tonight. I mean, they have to go through the variance application procedure, I believe.
The hearing, let me think about that. This hearing was properly noticed. It was begun in March, and it was continued to today. Would we need to, as a matter of process,
Is the gentleman sitting, is he our town lawyer or not?
Yes.
Oh, okay, good.
Another hearing. For the, this has been properly noticed for the.
What is it specifically been properly noticed for? If you're limited to whatever this has been noticed for.
The conditional use, but, okay, I mean,
I don't know that, well, if it would please the board, we can properly notice a variance in addition to the conditional use, but
Does the fact that this is a straw vote change that analysis at all, in that if it's a straw vote this evening on a conditional use and a variance request, presumably someone could show up at the next meeting and speak if they had an issue, but it could be incorrect, I don't know.
And the conditional use would not be able, we would be unable to grant the conditional use without varying those conditions. I mean, that's been the case from the beginning, and that's,
All I'm doing, I'm not, although it may appear that I'm trying to be an obstructionist, I'm trying to prevent the problems that have existed apparently in the past, where we have, I say we, the board preceding me approved things that they shouldn't have approved. And I truly believe, and I will defer to council on this, but I truly believe if we vote for a variance this evening, somebody could challenge that variance because it wasn't properly noticed and it wasn't properly therefore voted upon. I mean, if the board disagrees with me, speak now, or forever hold your peace, as they say.
Solomon?
Well, I think I answered. I think you're limited to whatever notice tonight. You're limited to your action.
Exactly.
Whatever was noted.
So what,
In order to be extra cautious.
well, in non-lawyer terms, you're saying that we should not vote on the variance tonight? Okay, thank you.
Yeah. But then I guess the variance is.
it was the conditions, so one of the conditions one of the conditions that is required to grant a conditional use approval for a religious place of worship in a residential district is the parking may not be within 50 feet of a lot line. And so what Mr. Martin is saying, I believe, is that in order to grant that conditional use approval, we need to vary that condition.
Exactly.
And in order to vary that condition, we need to properly notice the variance of that condition, which has not been done. So I'd be happy to properly notice that variance.
I mean, unless, I'm one person here.
Yeah.
If anyone disagrees, please say so.
I mean, it sounds correct to me as well, and you just agreed to it too, so I make a motion for continuance again.
And we're gonna be here next month anyway, so let's be cautious and err on the side of caution, and let's do it that way.
I guess protocol, we have a motion and a second, so we need that motion withdrawn.
That's fine. I'll withdraw that motion and make a motion to adjourn, or to postpone the hearing for another month.
Continue the hearing?
Continue the hearing, to allow it to be noticed for both a conditional use and variance request.
Okay, so we're gonna continue the hearing on the conditional use, and we will properly notice a hearing on a variance. Okay? Very
I'll
good.
bring snacks next time.
There's a motion, is there a second on that?
I second the motion.
Okay, a motion has been made and seconded. We'll do a roll call vote on that motion.
Mr. Grubbs?
Yes.
Mr. Martin?
Yes.
Mr. Price?
Yes.
Mr. Reininger?
Aye.
Mr. Bartold?
Yes.
So that motion will be continued, and we will look at that at our next meeting.
We're trying to prevent problems
We
in,
need to do it right.
we're trying to prevent problems, I think we all are trying to prevent problems in the future. That's absolutely true.
You're in a stuck position
Right.
because of history.
Right.
And and try to move forward judiciously, and I appreciate it.
We like seeing you, but we don't want to see you in 3 years.
I don't want to see you either.
Okay, let's move through the rest of the agenda very quickly. I have no other resolutions for adoption. I have no unfinished business. We have minutes from the March 27th meeting. I think all of you should have a copy of that. I'd ask for approval of those. If there,
Motion to approve the minutes from the 27th?
thank you, Mr. Price. Is there a second?
I'll second, but then I'll ask Mr. Mills a question. Do you really want to be quoted as saying that Mr. Mills said a condition of the conditional use approval would be that future improvements in the site must be in accordance with the code? Because then I think that's going to present the whole same problem again.
Say it again. Where are we at?
Well, we're in the middle of the page there. I think it says, Mr. Mills said a condition of the conditional use approval would be the future improvements to the site must be in conformance with the code.
What page are we on?
2. I just got these tonight as we all did, so I kind of breezed through them quickly, but, it's kind of a moot point now, but in that context, I think what you were saying was we could, the fault is not the applicant's. Mr. Mills, about two-thirds, three-quarters of the way down. Mr. Mills said a condition of the conditional use approval would be that future improvements, then they would have to comply with the 50-foot setback requirement.
Hard time finding it. Oh, there it is. Okay. Condition of the conditional use approval. Future improvement.
I don't think that's what you were saying at the time, but
I think that's right. The condition of the conditional use approval. Well, I mean,
that's fine. I mean, it's not,
yeah,
it's not,
I don't see a problem with that. I mean, you could be.
I think that's what you're saying tonight, isn't it? That, if the church came back to you in the future, you would have to meet the conditional use
Yes.
at that time.
Right. And you're
Versus we're going to give them a variance.
right,
for
so they
today.
don't have to.
right.
I think what we were trying to accomplish was trying to figure out how they wouldn't have to meet those, because they can't meet those requirements in the future. So that's all.
Right.
With that,
They just
Caveat.
can't diverge any farther from our ordinance.
Right.
It has to be in keeping with the ordinance from here on.
There's a motion and second on the minutes. I don't know if we need a roll call vote for approval or just all in favor.
I think all in favor. On minutes, you have to do roll call.
All in favor?
Aye.
Aye.
Okay. The records reflect I did not vote on the minutes since I was not part of that discussion.
Very good.
Administrative matters?
None. We have 2 plus this. 2 hearings next month plus this.
And motion to adjourn.
So moved.
Second?
Second.
Thank you. Mark, all in favor?
Aye.
Aye.
Thank you all.
thank you.